Okay, so assuming that's recording, seems to be. Where we left off was we had just, again, basically defined up federalism, and I gave you three different definitions as three different ways of kind of coming at it. I hinted that one of the things that you want to think about as you look at those definitions is the kind of strengths and drawback to the model. That if I have three levels of government governing the same people, that can lead to an increased number of tools to handle any issue, but it can also lead to overlap, redundancy, inefficiency, increased costs, friction, and we'll look at that as we go on. Ideally, as you specifically define up the types of power, it eliminates some of that friction, but what we see as we define up the types of powers is, for example, with implied powers, there's an ability for the federal government to grow its power. With reserved powers, what you're going to see later in the week, as you kind of explore parallel federal and state websites is, geez, there is an awful lot of overlap. The federal government definitely has expanded into the area that states usually were kind of autonomous in. So this next chunk of the lecture is going to look at how did that evolution happen? How did we get the expansion of federal power? Some of it is, I suppose kind of a natural evolution. Initially, when the United States was formed, you had state identification. People would say, I'm a citizen of Massachusetts, Connecticut, Pennsylvania, whatever state. Washington, D.C. was seen as an abstraction. It's, located, well, it jumped around. It was a New York and a Philadelphia kind of home. But when it comes to reside in Washington, D.C., it's a swampy kind of, wasteland that no one wants to go to, and nor can they. We don't have a communications network like we do today. So we're not, there's not telegraph or kind of, phone lines or anything like that would connect you to Washington, D.C. Today, you can virtually go anywhere and get a sense of a place. That's not in existence back then. Certainly the transportation networks weren't around. Travel to D.C. was long, arduous, tedious. Again, it's an abstraction. So as we get telecommunication and transportation kind of infrastructure put in place, we will get more connected with D.C. As we grow as a nation, our problems become national in scale. That's another reason D.C. begins to, and the federal government begins to have increased relevance and power. Okay, so some of it is natural as we, improve technologically, as we grow. There's a natural evolution. But what we're going to look at is, again, some of it is overlap from the last unit. There are a series of ways in which key phrases and key cases have been used to expand federal power. The last time we did this, we talked about just basically keeping the Constitution relevant. So we're going to do the same kind of steps, but we're going to do it now to expand the federal government, okay? And then what we'll look at is, in addition to these court cases, you have points in time where the other branches have taken an action in doing so, define the kind of the approach that we take with the balance of power. Precedents were set. What we'll see in this section, again, is types of federalism, that there's a kind of a philosophical approach as to where the balance is. It's part of kind of deliberate policies, and eventually a time period gets kind of named for that approach. So, for example, when Franklin Roosevelt comes in, he's looking to get us out of the Great Depression. And so he's throwing every tool he has at the problem. He's looking to expand the power of the federal government, but he's looking to do it in conjunction with the states and the local government. For that reason, that's called cooperative federalism. When Lyndon Johnson comes in, he's essentially trying to take it a step further, and it's not just the economy. He's combating poverty and the ills of racism, problems that are associated with cities, and he's looking to not just do it maybe in partnership. He's looking to if he's going to have to be coercive and use kind of the grants, he'll do it. If there's a private partnership that he can make, he'll do it. So, for example, Head Start is where we offer, essentially those are private nonprofit organizations that allow low-income families to get access to pre-K, to preschool. That's a creative approach. It's called creative federalism. All right. So big setup. What I'm saying is, we'll look at some stuff that's familiar, and then we'll look at some, I think, historic steps that presidents have taken in the past that are familiar. But what you're going to see is that there is a trend towards the approach of balance of power, and then there's a name for the type of federalism. Okay. And that's the key term work that you're doing, by the way. You'll have examples for each of those types of federalism to kind of illustrate that approach. You'll have policy examples of, what, Reagan might have done, what, Clinton did, all right? So, and those terms are due on Wednesday. Everyone kind of chunking away at that, right? I wouldn't leave that all for one night. Okay, so. Don't know if I'm still recording or not. You still there, Sydney? Is it still rolling? It is. It's going to be a weird recording, Sydney. All right. So those are the clauses that we're looking at. And again, we'll have companion court cases that define up those powers and lead to an expanded amount of power for the federal government. And we've looked at several times the necessary and proper clause, McCulloch versus Maryland. So I don't feel like I have to labor through this one. We're just, again, going to apply it differently. Instead of just talking about expanding the Constitution, we'll talk about expanding federal power. Some terminology that I may not have brought in as deliberately and as clearly as I should in the past. When you have this initial decision to make a national bank. Remember, there's tension between Alexander Hamilton and Thomas Jefferson. Alexander Hamilton is the one that's advocating for this national bank. He basically is a loose constructionist, or constructionist. What he's basically saying is, basically a loose constructionist says, I have to work at this, as long as it is not specifically prohibited, you can do it. As long as you don't say I can't do it, I can do it. You get that? That's how some of us approach, classroom behavior. As long as the teacher didn't specifically say, I can't do it, I can do it. A strict constructionalist, and that would be Jefferson, would talk about you can only do what you're specifically authorized to do within the Constitution. You have to look for places where things are explicitly stated, and there is no place in the Constitution where it says you have the explicit permission to create a national bank. All right? What we know is the court case was initiated because of Maryland's taxation on the bank. There's, background to that about how the bank is seen to favor northern interests. And, certain western and southern states don't like the bank and they're looking for a chance to oppose it. So this is a deliberate act by Maryland to challenge the authority of the bank. McCulloch, the teller, refuses to pay the tax. It goes to the Supreme Court. There's Marshall. Again, if you're going to know any Supreme Court justice, it's Marshall. Because, again, he's Marbury versus Madison. He's McCulloch versus Maryland. He's Gibbons versus Ogden. He's Fletcher versus Peck. And the other cases where we apply judicial review to the states. He's the one that gets them to issue decisions as a whole, as opposed to offering independent decisions. Man, does he define and transform the court. So, if you ever got a question about how an individual Supreme Court justice could impact the court, I could see that kind of question. Marshall, and you write for 5 days, okay? So, at any rate, he's the one that hands down the verdict that, not only upholds the necessary and proper clause, and in doing so gives, well, not upholds. If you notice the language, I'm kind of careful here. Here I talk about essentially the language was there, the word necessary and proper. What he's doing is crystallizing our understanding of that phrase. I suppose you can kind of make that argument. Like, we have speech, the right to free speech. That's there. But over time, our understanding of what it means in terms of having free speech and where the limits are crystallize. So, what the court is doing is articulating the meaning. And what's interesting is, certain justices have different judicial philosophies. Some are, trying to get to the original intent. What did the framers want? Some are, more, exercising kind of powers of judicial independence, and looking to kind of interpret without that constraint, I suppose. All right. So, at any rate, yes, there is a backdrop of judicial philosophy, but arguably what they're trying to do is get to the central truth that's in the document. And they're looking simply to articulate it, to clarify, to crystallize it. And, if I use that language, what I would say is that the court essentially clarified what was meant by the necessary and proper clause, that it includes implied powers as long as they are derived from the delegated powers. And in doing so, the federal government can now claim a virtually limitless array of powers. Because if you think of it, all you got to do is make some sort of connection to a delegated power. And if you can do that, new power for the federal government, right? It also upholds the supremacy clause, so that certainly expands federal power. So again, there's a clause that we're familiar with and a court case that we're familiar with, and what it does is it expands federal power, right? And that kind of clincher sentence is again how you would articulate it, how you would summarize it. Okay? Let's look at another one that you are familiar with, but we didn't necessarily go over it formally. Okay? So again, I've got a clause. I've got a kind of a vague bit of language. It's in Article 1, Section 8. That's where you're going to live, for half of your discussions with about the Constitution. What we see here is the federal government having the power, or Congress, having the power to regulate commerce among the several states. So this is called the Commerce Clause. I have power to regulate commerce among the several states, as well as foreign nations and with the native tribes. Okay? Where we get a expanded definition of that Commerce Clause, or where we crystallize an understanding of that Commerce Clause, comes with Gibbons versus Ogden. And again, I went over it kind of quickly. The video touched on it as well. This is a case where you have two rival steamship companies, both with an exclusive monopoly, because you are ferrying individuals, and you want not a lot of competition there because human lives are at stake. So we want to be able to regulate and make sure that whoever is taking people across the waters of New York to New Jersey and vice versa is doing so in a safe manner. So the federal government has exclusively licensed one company. New York has exclusively licensed one company. And the case is really to decide as to whose exclusive monopoly is the correct one. Which level of government has the right to grant this exclusive monopoly, all right? Again, it's Marshall. And again, he sides on the side of the federal government based on the Interstate Commerce Clause. So what's interesting, it may not have occurred to you initially. Well, of course, this is a ferry company. It involves income. The ferry company is going between one state and another. Of course, it's interstate commerce. Of course, it goes to the federal government. But you may have been doing it initially, and this is what we talked about because of the supremacy clause, right? I've got two competing kind of claims. I would use the supremacy clause to kind of sort it out. Well, again, he's using the commerce clause. And what makes this kind of earth-shattering is that he is defining the transportation of people as commerce. Today, I think we kind of see the economic value to almost every activity and the chance for profit everywhere, right? Back then, you just basically kind of talked about the manufacture, sale, and distribution of goods. We had a more restrictive definition of commerce. What they're doing here is they're saying the transportation of people is now commerce. So what it essentially says is the federal government can basically, because of this, regulate any commercial enterprise, any commercial activity, anything involving commercial value, as long as there's some sort of loose connection you can make that commerce takes place between states. Okay? We can manufacture not just the manufacture, distribution, and sale of physical products, but anything of economic value, as long as there can be some sort of connection between, states. So, for example, what's obvious might be insurance companies and telecommunication companies. They may have a corporate home, but of course, if you're licensing drivers, I mean, Pingree Insurance, for example, local family, local insurance company, and they, maybe that's when you first got your car. Your parents have a policy to insure your car, and you got added to the policy, right? But you're going to, at some point, likely drive across state lines. The car itself is something that has a lot of manufactured parts coming from different places that was manufactured somewhere else. The people there doing the paperwork and working on computers got that paperwork and the computer and the programming from somewhere else. So I can make a connection that even a local kind of mom and pop business, on some level, even if they got policies or ideas from other places, I can make an argument that a mom and pop industry is got some sort of connection to interstate commerce. Therefore, I can go in and regulate Pingree Insurance, right? Telecommunications industries. Obviously, there's radio waves, internet lines that kind of cross state lines. Where I want us to focus, though, is this idea of educational services, because that's where I think it gets interesting. Again, I had made the case a while ago that they upheld the Civil Rights Act and basically began to try to force state compliance using the Commerce Clause. Because here's the idea. You guys right now are in a local school. We're not even regional, right? You're in a local school. How could this have any relation to interstate commerce? How could the federal government come in and regulate our activities under the Commerce Clause? Well, I'm giving you ideas. Those ideas likely came from somewhere else. We're using textbooks that likely came from somewhere else. We're using, again, materials that came from somewhere else. You are going to take those ideas and you're going to go get jobs elsewhere. Might be in state, might not be, right? So on any number of levels, I can make a loose connection to interstate commerce. Quite simply, too, and this is the easier connection to make, the better the educational environment and the better educated you are, the better the local economy. Does that make sense? People move into communities where there's good schools, and businesses come into areas where there's a developing, thriving community. So if we have a poor educational system because of discrimination, then that affects the local economy, which in turn affects the national economy, because every place trades with another place. So based on that series of little bits of logic, I can regulate a school in terms of discrimination policy using the Interstate Commerce Clause. I can do it with private businesses too. Remember, the federal government had a lot of power to regulate state activity. No state shall, under the 14th Amendment. But private institutions could discriminate, right? They could say, I'm going to exclude certain people. I'm going to not hire, certain people. Well, again, I could use the Commerce Clause and make a connection to commerce and say, yes, you will. All right? Okay? So arguably, when you look at the way that we can creatively use the Commerce Clause, there's a lot of political scientists or historians would tell you that based on that definition, there is no limit to what the federal government can do with respect to claiming expanded powers under the Commerce Clause, until we had a couple of exceptions. And we'll look at those in a second. Again, look at how we, would summarize that. I think, you guys reading through the conclusion is helpful. That there's limitless power to regulate state activities, provided there is a connection to, and I should really change that to interstate commerce, but you have to have this multi-state impact. Now again, this would have been limitless, I would argue, with the exception of a couple of cases. So there's U.S. versus Lopez. What basically happened was schools are drug-free zones, gun-free zones, and that I suppose doesn't. It's not like we're under the illusion that those things don't come across into school zones. Anybody know the idea behind a gun-free zone or a school-free zone? What happens if you bring a gun or drugs into a gun-free zone or a school-free zone? Literally, you cross that line. There's a sign that says, no guns, no drugs within 1,000 feet of this building. What happens if you come in within the bubble? I'm going to pan the camera around. I got this. Deer in the headlight expressions. Increased penalties. Does that make sense? Like, it's a crime no matter what to have an unlicensed gun, but you bring it within a school zone and all of a sudden there's increased penalties. It's saying essentially guns and drugs are worse within this bubble and therefore we're going to penalize you more. Well, they upheld that through the Commerce Clause. Again, showing you that if this case had gotten upheld, it would be a way to show you, again, no limits to the Commerce Clause. What I suppose I could use it to show you is that potentially there was no limits. That this is the potential scope of the impact. The argument, again, was the one that I put forward. You bring guns into schools, you disrupt the educational environment, you therefore have a detrimental effect on the local economy, which in turn has a detrimental effect on interstate commerce. Okay? That was the argument, and that's what we used to kind of create the gun-free zones that led to the arrest of this guy, Alfonso Lopez, who had brought a gun into a school. 38 caliber, if that's of any interest. What the Rehnquist court ruled, and this is during the Reagan years, and the court had a kind of, there was a concerted effort to get some conservatives onto the court and to redirect the court. What's interesting is...
Please excuse the interruption. I'm not sure if you're aware, but the internet is back up. Thank you.
Great. What was interesting is that we'll look at a video later on in the Supreme Court series about how successful, we're going to talk about how many presidents have tried to return power to the states, and in many ways there's a momentum. It's once you kind of grow the federal government, it's really hard to shrink it. Similarly, once you've had several rulings, it's really kind of hard to overcome them. So even though a series of conservatives came in, they didn't undo Roe v. Wade. They didn't undo ideas about prayer in school. A lot of the conservative agenda didn't happen under conservative justices. It was more, you've established certain precedences in terms of cases. This is one of the rare ones that does get overturned, though, in terms of expanded power of the Commerce Clause. What the Rehnquist court, determined was that there is some limits to the Commerce Clause. And the connections that you're making, that guns will disrupt a local school, which in turn will disrupt a local economy, which in turn will disrupt a interstate commerce, is too distant. It's too much of a stretch. What basically the standard they came up with is it has to have kind of a more immediate and widespread impact. I need to, if this is going to be interstate commerce, then I need to see that guns in school have that more immediate and massive kind of impact, rather than this kind of philosophical impact. Does that make sense? All right. Prince versus U.S. is another one where, again, we struck down the federal government's nearly limitless amount of power under the Commerce Clause. What we have here is the Brady Act. I don't know if you guys, did you get to look at in any detail the assassination attempt on Reagan? Right? Okay. So we know that there was an attempted assassination on Reagan. We covered that in the U.S. and check. All right. So it's a guy named Hinckley who's mentally ill, and anybody who does anything like this is by definition mentally ill. But his particular delusion was that if I assassinate the president, I will impress an actress that he was obsessed with, Jodie Foster. And this is why he does this assassination attempt on Reagan. It's caught on video, so it's a kind of an iconic kind of moment. But what people miss sometimes is that there were other people caught in the crossfire, Secret Service agents, and notably Reagan's press secretary William Brady, who was this bright, shining kind of political star, the press secretary for the president, who had a head trauma as a result of this and was brain damaged and wheelchair bound. Well, he becomes the talisman. He becomes the kind of the image that we're going to use to kind of say that we need more sensible gun laws, that we need, you know, you can get into the whole argument that the guns aren't dangerous. It's the, you know, it's the mentally ill that are dangerous, and especially if they have guns. You know, what we need to do is address mental illness and maybe not the gun policy. Well, this kind of does, I guess, in the middle where it says, let's do some background checks. Let's make sure that, you know, guns aren't getting into the hands of criminals and individuals that are mentally ill. Waiting periods was another thing that it introduced. That, you know, we want to make sure that someone doesn't, in the heat of a moment, go get a gun, you know, at a moment's notice and use it because they're upset. So let's have a waiting period. There are other kind of restrictions, you know, we'll begin to talk about. Later on, there's an assault weapons ban that talks about, you know, you have a right to bear arms, but not an AK-47, not a street sweeper, which, you know, fires off something like 60 shots a second. You know, there are some restrictions that we begin to introduce. The problem isn't necessarily the restrictions and the Second Amendment. The problem here is that the background checks and the you know, other requirements to do all of this careful, you know, implementation and screening is put in the hands of the states. So here is a federal kind of requirement, but I'm going to have what's called CLEOs, local law enforcement officials, being the ones that are doing the background checks, being the ones that are trying to do some of the enforcement, okay? And that's where, under the Rehnquist Court again, we've seemed to have overstepped. Scalia is a conservative justice, and he comes up with this, you know, phrasing of the unitary executive. What it means is there is an executive in charge of the executive branch, and they're able to kind of, they are not only able, but they have the sole responsibility of kind of implementing the law. And the president can't pass the buck any further than that. Can't say, you know, okay, I'm going to kind of kick that responsibility to states. If you have a law and the president is in charge of implementing it, the president should figure out where within the federal bureaucracy to implement it, and not say, here, states, you do it. The other more major problem, and this is I suppose political as much as it is in terms of constitutional language, is my favorite joke all year. Maybe second favorite joke. I do like the you know, not Bear Claus, not Santa Claus, but Commerce Clause kind of joke. So this is an unfunded mandate. Unfunded mandate, all right? A mandate, if I mandate something, what am I saying? What word do you hear in it? This is a mandate.
Mandatory.
Mandatory. It's something you have to do. An unfunded mandate is, again, where I have not given you the money to do it. Or it's the guy that shows up for prom with no money and you're walking, right? And you got to spring for it. So my favorite, you know, that's my favorite joke there. An unfunded mandate is the dude that shows up with no money and wants you to pay for dinner, right? All right, and you'll remember it that way. No one likes the unfunded mandate. States hate it, and that's in part what you guys were reading about with the school lunch program, okay? So for both the constitutional reason, this idea of a unitary executive, we strike it down. But in addition, we're also, you know, there's a political issue swirling around about unfunded mandates. That if you are going to impose something that is, you know, mandatory for states to do, you better provide the funding. And I guess if you don't, you know, it is because you're violating the unitary executive theory. That, you know, the president is kind of passing the buck. Where we can look at this idea of the unfunded mandate is, you know, in a number of areas. But I guess I have it a little later in the notes. Like No Child Left Behind is another example. If you as a state don't have a competency exam, like we have MCAS, then you're expected to kind of come up with one. And Common Core is the most recent kind of incarnation of a kind of a standardized test that shows student achievement and teacher competency, right? So, okay, I want every state to have a test like that, but I'm not going to pay for it. You guys figure out how to construct the test, administer the test, grade the test, remediate from the test. All of those have associated costs, but we're not going to pay for it. And consequently, a lot of states look to opt out. And the question is, should they be able to, right? You read about school lunches. The federal government saying we want lunches. We have an epidemic of childhood obesity. We've got all kinds of health issues. That has associated costs as well. You're driving up the cost of insurance and health care for everybody. It would be better to do something preventative rather than wait for someone to get diabetes or a heart condition or something like that. So let's improve school lunches, but I'm not going to pay for it. You guys are going to come up with it. Plus, kids don't want to eat it if it's not covered in cheese, right? So you read about the kind of the backlash there. And part of the issue is, like I said, unfunded mandates. All right, general welfare clause. Again, I've got a clause. Again, I've got a series of cases. This one, I think, is perhaps some of the most confusing. So I'm going to give you a kind of a rule of thumb here before we get into it. Article 1, Section 8. And again, what we see is the power to kind of raise taxes and spend money. And that's where most of us stop because we think of it as a delegated or enumerated power. But if you keep going on, that power to raise taxes and spend money is there to promote the general welfare. All right? You have the power to collect and lay taxes, all this other stuff, to provide for the common defense and general welfare of the United States. Well, that gives me a bit of a tool because I can say I'm going to, take in money and put out money to promote the general welfare. And that is a vague clause that I can use to kind of say, well, I'm giving you money in order to get you to do something that I think is going to help us as a nation. Or, you see the power to tax there as well. The question is going to be, can I tax you? Can I use the power to tax to get you to do something because I think it promotes the general welfare? Now, the general rule of thumb is the court, through a series of New Deal cases, will say yes, that you can use distribution of money, allocation of money, to get states to do certain things, provided it's just that. It's an inducement, not coercion. If what you're doing is saying, here's money if you did something, and if you don't do it, I'm withholding that money, that's inducing. That's giving an incentive. If what you're saying is, do this, or I'm going to tax you, or I'm going to impose financial penalties, that's coercion. And that's where the limits are. And that's essentially what these court cases will lay out. So we start with U.S. versus Butler. And by the way, McCulloch versus Maryland, Gibbons versus Ogden, absolutely have to remember those. Those are bedrock ones. These are like secondary, if not tertiary kind of cases. And I think the rule of thumb is enough. If you do have one of those brains that, if you ask me, I know there's Helvering versus Davis, U.S. versus Butler, Stewart. I remember the cases. Sometimes I remember them in the right order. See if I got them when I turn around. So even I don't necessarily remember, like I said, the cases and the exact kind of issues at stake. What I do remember is the rule of thumb, and I think if you do the same, you're going to be okay. But at any rate, I was right with U.S. versus Butler. This is over the Agricultural Adjustment Act. What's interesting is, as a nation, we have the ability to produce, 5 times, the amount of food the world needs, essentially. Often the problem is distribution, not our ability to produce. Our yield, our ability to produce is amazing, right? There's an economic downside to that. Because we're so good at producing, because our supply is so high, and demand for food tends to be relatively stable, where's price? If demand is, relatively stable and supply is through the roof, how much you making on corn? Not a lot, right? So what does the federal government actually pay some farmers to do? Anybody know? It's kind of remarkable. What do they pay them to do? To not farm, right? Here's the logic. If agriculture was unprofitable, and it, you can kind of see that if our ability to produce is through the roof and people are making pennies, farming could arguably become unprofitable, and then there's a threat to our food supply. So we want to encourage people to farm, but we want to keep production levels at a place where it's profitable. We have enough and people are making money, and we perpetuate that industry. We want to keep that industry going. Well, we do that by paying farmers not to grow. The Agricultural Adjustment Act was challenged because what we basically had initially was the idea of, we will pay you not to grow, but if you grow and you violate the contract, there will be penalties. All right? So that's one of the places where they begin to define up the idea that this contract, this act was no good because it was coercive, because it included penalties. What's being suggested, though, is if it was just incentives, would have been okay. All right? And that's where we get to with Stewart Machine Company versus Davis. This is over the Social Security Act's component. The Social Security Act we often think of as just, what do we think of it as? Let's make sure you know what it is. What kind of benefits do we tend to think of the Social Security Act providing? Who gets benefits under that act? Social Security, one of our biggest expenditures. And I've got dull blank faces. What do you think, Mike? Senior citizens. You knew. You guys just didn't want to be on record for it, right? So it's, basically retirement benefits, right? Well, it also includes disability and other types of benefits. It's a bigger act than what we often think. So unemployment compensation is also under the Social Security Act. And the idea was, can I make states opt into this system in terms of, payroll tax and helping to implement and helping to fund? Can I get states to opt into this system by using incentives, financial incentives? You help us implement this act, we'll give you federal dollars. Don't implement this act and we will withdraw it. The answer was yes, because there weren't penalties. Okay? Remind me, I'm on Helvering versus Davis, and it's looking at the pension benefits. Everybody say goodbye to Sydney. Did you hear him, Sydney?
Olson to the guidance office,
Big booming goodbye.